Establishing a limited liability company offshore can provide an additional layer of protection over U.S. LLCs. The island of Nevis, down in the Caribbean in particular, enacted favorable LLC laws in 1995. A U.S. person, in turn, can use a Nevis LLC to run a business in the United States or other country, and it's just a matter of filing foreign qualification papers in the state or country where one wishes to operate. More commonly, a member may want to use the company to hold a foreign bank or investment account in order to help protect the funds from domestic lawsuits. I've been in the company formation business for well over a quarter century and set up my first Nevis company for a client in 1994. Have visited Nevis on several occasions and had a personal visit in my U.S. office from the current premier of Nevis, that's the island's head of state, and our team has established several thousand Nevis corporations and LLCs. The Nevis legislature amended the ordinance in 2015, which tremendously increased the asset protection benefits of the Nevis LLC. First of all, Nevis allows for single-member LLCs. That's an LLC with one owner. And Nevis law also establishes a charging order lien as the creditor's exclusive remedy to attack a debtor's ownership interest in a Nevis LLC, even if it's a single-member LLC. That is, someone with a judgment against the owner of a Nevis LLC cannot take the LLC nor the assets inside. And better yet, if a U.S. person or company has the charging order, the person holding the charging order, in other words, the one who sued, is required to pay taxes on that member's portion of the profits made inside the company, whether they receive the distributions or not. And that's according to Revenue Ruling 77-137. And that is because the one who has the right to receive the distributions is the one responsible for the tax bill, whether the profits are actually distributed out of the LLC or not. So one more time, yes, the one who sued you would now be responsible for paying your Nevis LLC profits tax bill, even if you decide not to make distributions to them from your company, and the suing party cannot force you to make distributions. Now, charging order liens in Nevis expire after 3 years, and they are not renewable. The Nevis Limited Liability Company, for U.S. citizens transferring assets into them in a single-member LLC, does not trigger the tax consequences that would normally be linked to the transfer of assets to other types of offshore entities. Now, Nevis does not recognize foreign judgments, and management in our Nevis office knows of no case where a U.S. creditor has ever obtained a charging order lien through Nevis courts to enable them to enforce a judgment from the U.S. And it gets even better. The 2015 amendment reduced the fraudulent transfer statute of limitations in Nevis to only 2 years. What that means is once you transfer assets into a Nevis LLC, 2 years later, the courts would refuse to even hear the case. And even better, the creditor must prove beyond the shadow of a doubt that the debtor transferred the assets into the Nevis LLC to hinder or delay that particular creditor. So informing the courts that you simply moved the assets into the Nevis LLC to diversify internationally may cast enough reasonable doubt against the fraudulent transfer accusations to keep the creditors at bay. Moreover, in 2015, the amendment makes a creditor post a $100,000 bond before filing the documents to enforce a judgment against a Nevis LLC member. In other words, before suing you and trying to get a charging order against your LLC in Nevis, they have to pay a $100,000 bond up front before they can even file a lawsuit. On the other hand, U.S. courts for U.S. LLCs hold consistently that creditors can foreclose on a debtor's interest in a U.S. single-member LLC through U.S. state court proceedings. U.S. LLCs have the charging order lien protection as well. However, the courts consistently break through the protection afforded by the U.S. LLC statutes. Not so in Nevis. So how does this help in U.S. courts? Now, additional amendments made to the 2015 Nevis LLC statutes can be very beneficial to defend assets held therein from attacks in U.S. courts. The 2015 amendment to the Nevis LLC statutes possesses verbiage protecting members who have charging order liens on their interest in the company. Now, that member's interest may be obtained by other LLC members who do not have liens on their membership. For example, let's suppose a company is owned by a husband, wife, and 2 children. The father gets a judgment against himself, and his interest in the LLC obtains a charging order. What can happen is the wife or children can obtain his interest in the LLC free from the charging order. Alternatively, he can redeem his own interest in the LLC with other assets, including assets that are exempt from judgment creditors. In addition, the new statutes provide that even if a member has a charging order against himself or herself in their LLC membership interest, he can still contribute additional capital to the LLC. Plus, if there are 2 or more members, the member that is free to make distributions may do so without the need to make distributions to the charged member that would result in seizure of that portion of the distribution. Now, the 2 prior conditions have to do with the inner workings of the LLC and its members. In just about all U.S. jurisdictions, issues having to do with intercompany matters and among the LLC members are regulated by the jurisdiction where the entity was formed and not where the LLC members or owners live. Please see Part 2.